So I think we should get started. I'm Jonathan Gingrich. Together with Kate Friedenberg, I co-convene this seminar series, The Practical, the Political, the Ethical. We are delighted to have with us today Professor Sophia Moreau at the University of Toronto, of both the law school and the philosophy department. She has a handout, which I'm going to share a link to in the meeting chat. Feel free to send a message to me privately if you have any trouble accessing the handout. Sophia will talk for the first half of the meeting, and then we'll have a brief break and go to question and answer. And just to let you know, the talk will be recorded so that it can be posted on the Institute of Philosophy YouTube channel. So if you want to avoid being recorded, just don't say anything during the talk, which should be easy. We will not record the Q&A. So with that, I will hand things over to Sophia.
Thanks so much. Thanks, Jonathan and Kate, for inviting me. Thanks very much to all of you for attending. I look forward to our discussion immensely. So I'm going to talk to you today about the prospects for a pluralist theory of wrongful discrimination. As Jonathan mentioned, there is a handout, but I'm putting it in the chat box rather than sharing my screen with you, because I find in these Zoom meetings that if one shares a screen that just has a bare bones handout, people spend the whole time staring at the handout and it becomes more difficult to focus on the talk. So you can look at it if you like. It really just has the briefest of outlines of what I'm going to talk to you about. So the COVID-19 pandemic has led to increased public awareness of many of the morally problematic forms of discrimination that are regularly experienced by racial minorities, women, people with disabilities, among others. But discrimination is quite difficult to theorize about. The particular grounds of discrimination that we normally take to indicate at least a prima facie moral problem are quite different. And they range, of course, from immutable traits like race to mutable traits like age and criminal record, and from traits that seem unconnected to our commitments, like certain forms of disability, say a herniated disc, to those traits that seem deeply expressive of who we are, such as our political or religious affiliations. Moreover, different forms of discrimination seem to harm people in very different ways. Some forms of discrimination perpetuate the unfair subordination of certain social groups. Others deny people important freedoms. Sometimes the harm seems best understood as an injustice that's done to a group as a whole, and other times it seems more like a personal wrong committed by one person or institution toward a single person. So all of these sorts of considerations may push us toward a pluralist theory of wrongful discrimination, one that holds that discrimination is wrong for different reasons in different cases. Interestingly, though, most of the general theories of what makes discrimination wrong that have recently been defended by moral and legal philosophers are what I call monist. That is to say, each of them traces the wrongness of discrimination to some single further disvalue, which is supposed to explain why discrimination on the basis of standardly prohibited traits is wrong when it's wrong. So for instance, the American legal philosopher Deborah Hellman has argued that discriminatory acts are wrong insofar as they violate laws, are wrong insofar as they demean people. By contrast, the British philosopher Tarun Kaitan, whom some of you may know, has argued that discriminatory acts are wrong insofar as they violate laws that function to give everyone access to the goods necessary for an autonomous life. So both of these theories are monist in the sense that I'm talking about. And to say that a theory is monist in this sense is not to say that it's insensitive to social context or that it appeals to only one kind of fact about discriminatory acts in explaining when the relevant value is engaged. It's rather to say that the theory traces the wrongness of discrimination to some single disvalue. In Hellman's case, that's demeaning people. And in Kaitan's case, that's failing to do what one needs to do to give everyone the necessary conditions for autonomy. Now, the theory of what makes discrimination wrong when it's wrong that I have defended in my recent book, Faces of Inequality, is by contrast pluralist, in the sense that it allows that discrimination can be wrong for different reasons in different cases, reasons that we can trace back to different problems with particular acts or particular social practices. Some discriminatory acts and practices are wrong for only one of these reasons, others for more than one. Now, in the space of this short talk today, I don't have time both to defend my theory on its own terms and to talk about the problems faced by pluralist theories or the advantages of my particular pluralist theory. I do in my book argue that the pluralist theory that I'm going to sketch out for you today both accords with our moral intuitions about a variety of important cases of wrongful discrimination, and makes the best sense of the basic structure that's common to many countries' anti-discrimination laws. But today, you'll have to take those arguments on trust. Rather than going through those, I'm going to do three things. I'm going to sketch out for you the theory, the bare bones of the theory, without defending it on those grounds. And then I'm going to turn to the two tasks that are, in a sense, my main tasks today. First, I want to talk to you about some of the challenges that pluralist theories of discrimination like mine face. And of course, I want to argue that my theory overcomes these challenges. And then I want to talk to you about some of the advantages of my particular pluralist theory. And I hope this will whet your appetite for the kind of longer defense of the view that you'll find in my book. Okay, so first, the theory. If you're following along on the handout that's available in the chat box, this is Roman numeral 1 on the handout. So the theory. I argue in my book that although discrimination is not always morally objectionable, it is sometimes the case that an act or policy that disadvantages some people relative to others on the basis of certain traits, thereby fails to treat them as the equals of others, and in so doing, wrongs them. It can fail to treat them as the equal of others, I argue, in at least three different ways or for three different reasons. First, sometimes it unfairly subordinates some people to others, marking them out as inferior to those others or perpetuating a state of affairs in which they have a social status lower than others. So here, you might think as an obvious example, the Jim Crow laws that segregated Americans into whites and blacks and gave blacks inferior access to inferior versions of the things that whites had access to. And you might also think of what even indirect discrimination does when it leaves certain social groups invisible in a certain area of society. For example, what happens to women when the male body is taken as the norm in a variety of contexts, such as designing crash dummies for cars, designing medical research studies, designing protective clothing for the army. There's a terrific book on this that some of you may have read by Caroline Criado Perez called Invisible Women. Which talks about many of these contexts in which women are rendered invisible because the male body is taken as the norm. And even if you haven't read that book, you probably noted when about a year ago, NASA had to cancel its all-female spacewalk, not because it didn't want to have it, but because it turned out it only owned one size medium spacesuit. So the problem there isn't the cancellation of the spacewalk. The problem was the initial decision only to buy a large number of spacesuits in size large when NASA was dealing with a situation where 50% of its graduating class since 2013 has been female. So those are some examples of policies that seem unfairly to subordinate some people to others or to perpetuate a state of affairs in which a group like women is rendered invisible. But discriminatory acts and practices sometimes do a different thing. They sometimes deny people what I call a deliberative freedom. This is item number 2 under Roman numeral 1 on the handout. What do I mean by a deliberative freedom? I mean the freedom not to have to think about a certain trait of yours or a certain ascribed trait not to have to bear the costs of other people's assumptions about this trait. So I talk in the book about how what is often called white privilege can actually be seen as a set of freedoms that racialized groups lack. The freedom, for instance, to drive down the highway or drive through Manhattan without being stopped by a police officer and assumed to be engaging in some kind of nefarious activity. Racialized groups are always aware of other people's perceptions of their race and need to spend their lives, in a sense, navigating around these perceptions. And that's a significant lack of freedom. Now, it's important, on my view, that we don't have a right to every single such freedom. But the thought is we do have a right to some, and discriminatory policies wrong people when they deny them a deliberative freedom that they have a right to. Thirdly, discrimination sometimes leaves some people without access to what I call a basic good. That is, a good that certain people need to have if they are to function as equals in their society. So one example in our current societies, whether you're dialing in from the UK or from North America, is marriage. Eligibility for marriage, which for a long time same-sex couples did not have in the UK or the US or Canada. The point here is not that every same-sex couple wants or needs to marry. The point is that given the function, the symbolic function and the status-giving function of marriage in society, you need to be regarded as at least eligible to marry if you are to be seen as the social equal of a heterosexual couple. So I try to show in the book that many cases of discrimination that we consider morally problematic do at least one of these three things. That is, either they unfairly subordinate some people to others, or they deny people the deliberative freedom that they have a right to, or they leave some people without access to a basic good. Now, the theory is pluralist because it doesn't assume that any one of these things is reducible to any of the others. Each, I argue, is different from the others and on its own sufficient for wrongful discrimination, though as you're probably thinking, many cases of discrimination are wrong for more than one of these reasons. I should also add, and this should be clear from the way I've framed it on the handout, that I don't claim that these three kinds of harm are in any way jointly exhaustive of the ways in which discrimination wrongs people by failing to treat them as equals. I just argue that when you think of them together, they explain many of our intuitions about core cases of direct and indirect discrimination that seem troubling. And they also make sense of basic features of the law. And I'm happy to talk more about those arguments or points during our discussion. Okay, moving along now to challenges for a pluralist theory of discrimination. This is Roman numeral 2 on the handout. Now, one worry that any pluralist theory of wrongful discrimination needs to confront is obviously a worry about explanatory power and arbitrariness. Pluralist theories of any moral phenomenon risk achieving their nuance, their sensitivity to facts, at the expense of their explanatory power. Why? Well, instead of offering us an explanation of why something like discrimination is wrong, they may seem to offer us just a list of the circumstances in which it's wrong, without any good justification for why these items should be on the list and not others. Now, this is a familiar concern with a long pedigree. It has been voiced, for instance, in relation to objective list theories of well-being. Scholars have argued that rather than being theories of what well-being is, objective list theories are really just lists of the things that contribute to our well-being: valuable personal relationships, a rich and satisfying career, and so on. Without a single underlying value to tie the items on the list together, such theories appear to give us no real explanation of what well-being is, and no reason other than intuitive plausibility for thinking that it's these items and not others that belong on the list. So you might be thinking the same thing about this pluralist theory of wrongful discrimination. Instead of offering us a theory of what makes discrimination wrong, maybe it only gives us a list of the circumstances in which it's wrong. And if all it provides is a list without any underlying and unifying explanation of why certain things are on the list and other things are not, then how is it really a theory at all? Well, my reply to this worry is to highlight the fact that on my theory, the items on the list are actually linked by two features that help to explain why they are on the list and why other items are not. So the first is a feature of all cases of discrimination, qua discrimination, one or more people are disadvantaged in relation to others on the basis of certain traits. The second is a feature of all cases of wrongful discrimination, and this is something obviously I argue for at much greater length in the book. Wrongful discrimination fails to treat a person as the equal of others. We can fail to treat someone as the equal of others because we subordinate them or their class to others. We can fail to treat them as the equal of others because we infringe a right to deliberative freedom. And we live in societies that hold up as a social and political ideal the idea that each of us ought, as far as possible, to be treated as though we were capable of autonomy. So that means that when we deny someone a particular deliberative freedom that they have a right to, we fail to treat them as the equal of others. And finally, discrimination can fail to treat someone as another's equal because it leaves them without access to a basic good. And you'll remember I defined a basic good as something that you need in order to be and be recognized as the equal of others. So the items in my pluralist theory aren't unconnected items on a list with no explanation of why they belong there. My theory does offer us an explanation of why subordination, infringements of deliberative freedom, and denials of basic goods belong on our list of the wrongs done by discrimination. Why? Well, they are all ways in which one fails to treat some people as the equals of others when one treats them differently on the basis of certain traits. Now, it might seem to you that this reply has taken me out of the frying pan into the fire. Why is that? Well, you might say that although this might satisfy you that the different components of the theory are connected, now it's unclear whether it's a genuinely pluralist theory at all. And I'm going to try and convince you, obviously, that it is in the relevant sense. This is because what explains why discrimination is wrong on my theory isn't just the bare abstract idea of failing to treat someone as the equal of others, but the quite particular explanations I give of what is involved in failing to treat someone as the equal of others. Unfairly subordinating people, or infringing their right to deliberative freedom, or leaving them without access to a basic good. So when we ask when and why is discrimination wrong, we could just say, insofar as it fails to treat some people as the equals of others. But this would be an incomplete answer because it wouldn't explain what it is for a discriminatory practice to fail to treat some people as the equals of others. We need the more particular and irreducibly different explanations that I've provided by appealing to things like unfair subordination and deliberative freedom and particular basic goods, if we're to understand what exactly is involved in failing to treat some people as the equals of others. A different way of making the same point might be to borrow Rawls's distinction between an abstract concept and a substantive conception of that concept. What I'm trying to suggest here is that the different reasons why discrimination is wrong, the different parts of this pluralist theory, give us different substantive conceptions of the very abstract concept of discriminating against someone in a way that fails to treat them as the equals of others. So the thought is that's why the theory can at once have explanatory power, but also be, in an important sense, pluralist. Okay, I'm going to move on now to a different worry that one might have about a pluralist theory of discrimination. And it's a worry about the distinctiveness of the wrong involved in cases of discrimination. Now, my theory recognizes, as I've tried to emphasize at various points in the talk, that not all discriminatory practices are wrongful. They become wrongful when they fail to treat some people as the equals of others, and they can fail to treat some people as the equals of others for a number of different reasons. However, at least some of these reasons are also reasons why other kinds of acts can be wrongful. acts that are not acts of discrimination because they don't involve distinguishing between different people or disadvantaging people on the basis of, say, the kinds of personal traits that would normally appear on a list of prohibited grounds, nor indeed on the basis of anything that could accurately be called a personal trait. For instance, so I can mark some people out as inferior to others, such as myself, simply by following certain social conventions, such as pushing people to their knees when they approach me. If I do this to 20 people, not on the basis of any trait that these 20 people share, but entirely at random, I'm still marking out these people as inferior to me, and my behavior is likely wrongful, but I'm not discriminating against them. My account then has the implication that some of the reasons why discriminatory practices are wrongful are not reasons that are unique to cases of discrimination. There are sometimes also reasons for thinking that non-discriminatory practices are wrongful. Now, is this a problem? I don't think so. Many moral theories imply that acts of different kinds are wrong for the same reason. So it can't be that this conclusion is problematic in the case of discrimination because somehow, as a general rule, it's implausible to think that different kinds of acts could be wrong for the same reason. I think if it seems problematic for a theory of discrimination, this must be because we are assuming that wrongful discrimination is somehow especially heinous as compared with other kinds of wrongdoing, and therefore that acts of wrongful discrimination must somehow all be wrong for the same special and particularly weighty reason, a reason for which no other kind of act similarly is wrong. Now, it's certainly true that within the popular media, charges of discrimination carry with them a particular and uniquely powerful kind of stigma. Discrimination is thought of as a particularly serious wrong, and we often assume that discriminators are particularly blameworthy. And so it might seem that only an account of wrongful discrimination that traces the wrongfulness of discrimination to some unique feature of discriminatory acts shared by all and only these acts could explain this stigma. You see, I think a bit of this reasoning underlying a view that I mentioned at the start of my talk, Debbie Hellman's view that discriminatory acts are wrongful insofar as they demean others, because she arrives at that view by thinking about what it is that might make discriminatory acts especially and heinously wrong. And she aims to find some single thing that all and only these sorts of acts have. But I think we should pause before accepting the idea that discriminatory acts are, as a group, especially heinous, or their agents particularly blameworthy. Practices that wrongfully discriminate vary enormously. Within the class of direct discrimination alone, some acts are done out of malice or prejudice. Others are done with a kind of nonchalant lack of concern for the discriminatee. Others are done with genuine regret, but motivated by financial concerns. And still others, genuine instances of direct discrimination, are motivated by a sincere but misplaced desire to assist discriminatees. You might think here of community centers in areas of racial tension that try to eliminate the tensions by posting different opening hours for different racial groups, which then ends up simply exacerbating tensions and hearkening back in problematic ways to eras of racial segregation, even though the intent was utterly benign in this case, in the case of the community center. Within the class of indirect discrimination, similarly, there's quite a range of different cases. There are cases in which an agent is fully aware of the impact of a certain practice on a certain social group. There are cases in which the agent is unaware but chooses not to investigate. So there's kind of willful blindness going on there. There are still other cases in which the agent is unaware that there's even an issue that they could investigate. So it's unclear that all of these are equally heinous. Do all of the agents seem equally deserving of blame? I think these differences cast doubt on the view that all wrongfully discriminatory practices are equally and stringently wrong. And if only some are particularly serious moral wrongs, then maybe their particular moral seriousness stems not really from what makes these acts wrongful, but from certain special facts about the agent in these particular cases. Maybe facts about their motives, or facts about the information they had available to them, or sometimes facts about their special roles or responsibilities. So it seems to me that the heinousness of some acts of wrongful discrimination doesn't provide us with a reason for thinking that there's a flaw in any theory of discrimination that traces its wrongness back to some feature that's had by other sorts of acts as well. And as is implicit in the remarks that I've just made here, I think we need to be quite careful and distinguish between what it is that makes an act wrong and what it is that makes an agent blameworthy. This is a distinction that's probably quite familiar to the lawyers in the room, especially those who work on areas like tort law, because of course tort law standardly says we're making judgments of responsibility and liability without necessarily imputing blame. So I find that legal scholars are quite comfortable with this distinction. Some moral philosophers, though, are less comfortable and think that we ought to tie wrongness quite closely to blame. We can talk more about that during our discussion period. Okay, I want to move on now to section Roman numeral 3 on the handout, advantages of my theory. So my theory offers us, firstly, a rich and nuanced understanding of what goes wrong in cases of discrimination. And I think it helps us pry apart the different wrongs that might be involved even in a single case of discrimination. And rather than requiring us to focus on one sort of fact, such as the demeaning nature of certain discriminatory practices or the way in which they restrict our freedom, my theory enables us to see how a number of different harms that these practices cause could all be relevant to whether and in what ways they are wrongful. And this is important because the theory enables us to explain and validate many claimants' thoughts about the specific ways in which they have been wronged without oversimplifying their complaints. Now, incidentally, it also helps to explain those cases where we feel that someone will be wrongfully discriminated against no matter what the agent does. In some of these cases, I think that what's really going on is that of the available alternative policies, each one wrongs some individual or group, but in a different way or for a different reason. One nice example of this is the case of Manuel Wackenheim and France, which came before the European Human Rights Committee. You might be familiar with the case. This was a case involving a French ban on the sport of dwarf tossing, which I didn't realize even existed as a sport before I read this case. France had banned dwarf tossing, saying that it was wrongfully, the sport itself was wrongfully discriminatory as against those suffering from dwarfism. But Mr. Wackenheim himself was a person suffering from dwarfism who was employed and argued that his only form of employment was through this sport, and said that in my terms, he argued that the ban denied him a job and thereby denied him a basic good. So rather than having to suggest in this kind of dispute that one party is wrong about wrongful discrimination, a pluralist theory like mine enables us to say, no, they're actually both right. Each of the alternatives wrongfully discriminates against someone. When you deny Mr. Wackenheim a job in dwarf tossing, given the current state of discrimination against those with dwarfism in France, you deny him a basic good. On the other hand, when you don't ban the sport of dwarf tossing, you contribute to the subordination of dwarfs as a class. Then, of course, we need to have a discussion, as we do in any case that poses this kind of moral problem, where we wrong someone no matter what we do. You need to have a further discussion about these sorts of wrongs and how they might weigh, what their relative weights might be, and of course, what the interests of others are that are relevant. This isn't something I have mentioned at this point, but up to this point, but I do have a section of the book where I talk about justification and the sorts of things that might justify an act that is wrongfully discriminatory, and we can talk about that again during the discussion period if that's of interest to you. The point I want to make here is simply that if we think about discrimination as wrong for these different reasons, it allows a more nuanced analysis of these cases that does take seriously the very different kinds of complaints that complainants and also governments trying to rectify discrimination seem to be thinking of when they make their policies or when they bring their complaints. So I've just given you one small example of this. Obviously, the fact that my theory is nuanced and makes sense of the perspectives of those involved in disputes about discrimination is not something I can prove here in the abstract before you today. You need to read the book. But there are other advantages of my pluralist theory that I think can be helpfully discussed in the abstract. So these are the ones that I want to focus on in this last section of my talk. So legal and philosophical scholars and also courts and tribunals deciding cases of discrimination have for a long time disagreed on a number of fundamental questions about discrimination. One of these is concerns the way in which claims of discrimination are comparative and how we're to determine what the relevant comparator group is in a given case of discrimination. I'm from Canada, of course, and our own Supreme Court has spilled so much ink over this question, and it has still actually really made no progress. There are still longstanding disagreements over how to figure out the relevant comparator group. Another source of disagreement is whether anti-discrimination laws aim to protect individuals or groups. And a third concerns the relationship between direct and indirect discrimination. Now, the fact that practitioners and scholars might together disagree on fundamental questions within a particular area of the law, or that moral philosophers might disagree on these sorts of questions in their inquiries within moral philosophy is hardly surprising, but usually some incremental progress is made in resolving the question, or at least in laying out what's at stake in the dispute. And it's unclear that we've made even this kind of basic progress in thinking about discrimination. So I want to suggest that my pluralist theory can actually help us, not just in resolving these disagreements, because of course there's a sense in which any theory can resolve any disagreement, but in resolving it in a way that's both plausible and explains why the discrimination persists. I think in cases of persistent disagreements like this, we need the kind of resolution that doesn't just swipe the disagreement under the carpet, but actually explains why there would be such a disagreement that lasted for so long. And hopefully a pluralist theory can do this. So first, I want to look at the puzzle about the ways in which judgments of wrongful discrimination are comparative. It seems that in order to make judgments about wrongful discrimination and to assess whether the discrimination was in fact wrongful, we need to compare the discriminatee with certain others. And it seems that the judgment that someone has wrongfully been discriminated against says something about the discriminatee relative to others. But which others, and on what basis are we supposed to compare them? Scholars and courts have found it quite difficult to settle on a single answer to these questions. Now, my theory can help us get us through this impasse because it suggests that the relevant comparisons, firstly, are not with the actual or hypothetical persons who have been or would have been given the immediate good that the discriminatee has not been received. So if someone is denied a job, it's not obviously the case that when we're thinking about whether this discrimination is wrongful, the relevant comparison is with the person who got the job. Rather, the relevant comparisons are those we need to make in order to assess whether the practice that disadvantaged the discriminatee has failed to treat her as an equal in any of the three ways that I have considered. And this depends on a number of different comparative judgments, depending on which conception of failing to treat a person as the equal of others is relevant. If we're concerned with unfair social subordination, we need to compare the power, authority, and visibility given to members of the allegedly superior social groups with that of the subordinated group. If we're assessing whether a certain practice or act infringes someone's right to a certain deliberative freedom, will need to ascertain whether she's forced to have that trait before her eyes or to bear the costs of that trait and other people's assumptions about it in circumstances where others don't have to bear the costs of similar traits, the costs, say, of their race or of their religion. So this will involve comparisons of the fixed costs and the opportunity costs accruing to bearers of different traits of the same type. And if what is at issue is whether a certain discriminatee has been denied a basic good, then it will be relevant whether others in his or her society also enjoy this good. Although in ways that we can talk more about in the discussion period, I think a good can be necessary for a certain person or group to function as equals without being necessary for everyone. So such comparisons will never be dispositive. So I've suggested that on my pluralist view, different comparisons are relevant in different cases, depending on which wrong is at issue. And I think this may help to explain why these disagreements about the relevance of different kinds of comparisons have persisted. According to my theory, different comparative judgments with either actual or hypothetical comparators are necessary, depending on the wrong that's at issue. Sometimes we need to make actual comparisons between the discriminatee and their social group on the one hand, and members of other social groups on the other. At other times, such as when we assess the opportunity costs of a rule for a particular claimant in order to determine whether they have a right to a particular deliberative freedom, we need to invoke hypothetical judgments about what would have happened to the claimant under different circumstances if they had lacked this trait. So that suggests that there is some truth to each of these views, some truth to the view that it's an actual comparator that we need, some truth to the view that it's a hypothetical comparator, some truth to the view that it's a particular individual, some truth to the view that it's a particular group. It just depends on what particular wrong is at stake in a given case. A further long-standing puzzle about discrimination concerns whether it's primarily a personal wrong akin to a tort, or primarily an injustice to particular social groups. Now, interestingly, anti-discrimination laws have some features that suggest that the wrong to which they're responding is a personal one, and they have other features that suggest that they're aiming to rectify a group-based injustice. For instance, many private sector anti-discrimination law regimes rely on individual claimants to instigate legal proceedings against alleged discriminators, and the claimant is, at least nominally, treated as though she's bringing a personal complaint akin to a tort against the discriminator. Moreover, many of the available remedies in private sector anti-discrimination law are personal ones. So for instance, discriminatees can seek personal accommodations from employers, reinstatement in their jobs, or some equivalent monetary compensation, as well as special damages for personal injury to their dignity or self-respect. But at the same time, interestingly, there are many more transformative remedies that are also available, remedies that are designed to fundamentally alter discriminatory practices toward a group as a whole, not just to carve out a tiny personal accommodation for the claimant. So remedies can include mandatory educational programs for discriminators, quotas, and other changes in hiring practices that are, for instance, designed to help a much larger portion of the social group to which the claimant or the discriminatee belongs. Remedies can also include orders to replace a particular wrongfully discriminatory practice with one that's inclusive of a social group that has certain needs and that doesn't single out members of this group as different. These more transformative remedies have suggested to some people that anti-discrimination law is addressing a group wrong or injustice and not at all or not only a personal wrong done to the claimant. Now, how does my pluralist theory help us here? Well, I think it can allow us to see all of these structural features of anti-discrimination law as reflecting different aspects of the moral truth about discrimination. For discrimination on my pluralist theory sometimes involves personal wrongs and sometimes involves group wrongs. And moreover, because a particular practice that's discriminatory can be wrong for multiple reasons at the same time, the same case can actually involve both personal and group wrongs. I should add a clarificatory note here. The group wrongs that I talk about, at least in the book, are not wrongs to some separate entity, a group over and above its different members. So by group wrong, I do mean a wrong that's done to each of the group's members by virtue of their membership in that group. But what distinguishes group wrongs in that sense from personal wrongs is that in the case of a personal wrong, one has some kind of unique personal claim for a special form of redress. So on my view, the wrong of infringing someone's deliberative freedom and the wrong of denying someone a basic good are personal wrongs in the sense that they generate personal claims for redress on the part of the discriminatee. But the wrong of causally contributing to or sustaining the subordination of a particular social group is not a wrong that generates a claim on any one person's part to any special kind of restitution over and above the measures that need to be taken in order to ensure that the group as a whole doesn't face this kind of discrimination in the future. Okay, there's also a third persistent puzzle that besets our thinking about discrimination and also our legal practices involving discrimination, and it concerns the relationship between direct and indirect discrimination. Many scholars have questioned whether indirect discrimination is indeed a form of discrimination at all. In their view, it's just too different from direct discrimination to be an instance of the same kind of wrong. And some have questioned, in fact, whether indirect discrimination is a wrong at all. Some have suggested, and I think their worry here can be put in the language of the American political philosopher Judith Shklar, somebody, by the way, who is often forgotten but was a huge influence on Rawls, and her work is deeply worth reading. So if you haven't, I would urge you to read it. She makes this wonderful distinction between an injustice and what she calls a misfortune. The idea is that a misfortune is a harm that we have a good reason to try to rectify, but not the kind of reason that generates an obligation in anyone else or a claim on our part, the victim's part, to rectification. So some people, I think, feel that direct discrimination is wrongful. It generates a claim to rectification on the part of the victim, but indirect discrimination is just what Shklar would call a misfortune. It doesn't generate any kind of claim. It's not a wrong. So that is one view. Others, on the other hand, think that the two are both wrongful. Now, I don't have time to argue in detail here for the conclusions that I reach in the book about the relationship between direct and indirect discrimination. So I'll just let you know what they are, and perhaps we can talk further during the discussion period. Although my theory is pluralist, it doesn't draw a morally significant line between direct and indirect discrimination. On the contrary, in ways that you could probably anticipate by thinking more about section 1 of my talk, I suggest that sometimes discrimination of each type wrongs people by failing to treat them as equals. As I mentioned at the start of my talk, direct discrimination of the Jim Crow law sort constitutes subordination, but so can forms of indirect discrimination, such as these practices that take the male body as the norm and render women invisible. And the same is true of denials of deliberative freedom and leaving people without access to a basic good. These can happen both by direct discrimination and by indirect discrimination. So the relevant question when we're thinking about discrimination in light of my theory isn't whether it's direct or indirect, it's whether the particular case of discrimination before us, the particular act of distinguishing people between people on the basis of a certain kind of trait, fails to treat some as the equals of others in one of the ways that I've described. Does it unfairly subordinate some to others? Does it deny some people a deliberative freedom to which they have a right? And does it leave some without access to a basic good? That's the morally relevant question, not whether something is an instance of direct or indirect discrimination. Okay, this brings me to the end of my remarks. I haven't tried to defend all of the claims that I've made today, but I hope I have given you a window into a particular theory of wrongful discrimination and some reasons for thinking that it can both overcome the initial difficulties that a pluralist theory of wrongful discrimination seems to face and provide some plausible answers to some of the puzzles that persist today in our thinking about discrimination. Thanks very much, and I look forward to your questions after the break.
Thanks for that wonderful talk, Sophia. We'll now take a 5-minute break, and so people can rest their eyes and grab a cup of tea or anything like that. And we'll come back in 5 minutes for the Q&A.